This Honorable Court of Appeals of Tennessee is now in session.
Good morning and welcome to the Tennessee Court of Appeals. We appreciate you agreeing to participate in this oral argument via Zoom. It's something that we've been using for quite a while and normally works pretty well, but if we experience any technological glitches, just bear with us and we will get those resolved and make sure nobody suffers because of it. Both of you are experienced attorneys, been to the Court of Appeals before. Just wanted to remind you that we will be utilizing the same rules and practices and procedures as if we were all standing in the courtroom together. Before we start, though, I want to take a moment and introduce our panel. We have Judge Kenny Armstrong from Memphis, Judge Carmen McGee from Savannah, and I'm Steve Stafford from Dyersburg. Ms. Tivner, anything we need to take up before we get started?
I know, Your Honor.
All right, you may call the case, please.
Rarity Bay Partners versus Rarity Bay Community Association, Inc. et al.
And we will hear from the appellant.
Good morning, Your Honors. I'm Dana Pemberton, and may it please the court, I'm here on behalf of the Rarity Bay Community Association as the appellant in this case. I will refer to it as the Homeowners Association. We are here based upon the court's order of February 10th, 2021, wherein the court ordered that the Homeowners Association produce ballots in its 2019 election, unredacted ballots that would reveal the identity of each voter who voted in that election. We submit that the court's order was erroneous for three reasons. Number one, the court ordered the production of ballots pursuant to the Tennessee Nonprofit Corporation Act. The act does not require production of election ballots. Number two, there is a right of privacy for the voter in this Homeowners Association election that would be violated if those ballots were required to be produced. And number three, although the court issued a protective order, the protective order does not sufficiently protect the voters' privacy rights in casting their vote in this election. The Tennessee Nonprofit Corporation Act, the pertinent statute is 4866-101 that deals with the records that the corporation is required to keep, and 4866-102 that deals with inspection of the records. In 4866-101, the only subsection that deals with election records is subsection C, where the legislature requires the corporation to keep a list of all of its members who are eligible to vote and required to show that that they're eligible to cast. That's the only election record that the Nonprofit Corporation Act addressed with respect to elections. The legislator had an opportunity to go further than that, and it chose not to do so. And what the Appellee is asking this court to do is essentially rewrite that statute to say what it wishes for it to say. It relies upon subsection E4 to state that it's entitled to election records. And that section states that the minutes of all meetings and members and records of all action approved by the members means that that refers to and encompasses election ballots. The Court of Appeals has spoken on a similar matter in the Siegel case that dealt with a condominium association, but the language is very similar to the Nonprofit Act that we're here on. The court analyzed whether or not the word minutes was sufficient to require production of election ballots, and the Siegel court said it was not. The court analyzed an even broader language in the Condominium Association Act that used the phrase all records, that they were entitled to all records. And the Siegel court decided that that language was ambiguous and did not encompass election records. Importantly, what the Siegel court did was analyze the intent of the legislature with the backdrop of the right of privacy in casting one's vote. The Appellee attempts to say, well, the use of a ballot in this particular election is not sufficient because it doesn't say secret ballot. Well, our state constitution doesn't use the word secret ballot either. And yet citizens have the right to privacy in their vote. Our Tennessee Supreme Court has interpreted the use of the word ballot in elections in its Mooney versus Phillips case. It dates all the way back to 1938. And what our Supreme Court said, because our state constitution at Article 4, Section 4 references that all elections will be by ballot, not secret ballot, just ballot. But our Supreme Court stated, and if I may quote, the prime object of constitutional provisions that voting shall be by ballot is to ensure secrecy to the voter in expressing his choice between candidates. It is reasoned that the word, quote, ballot, end quote, is not used in a literal sense, but merely by way of designating a method of conducting elections that will guarantee the secrecy and integrity of the ballot. There's no question in this homeowners association election that a ballot was used, a written ballot, pursuant to the procedure allowed by the bylaws in this homeowners association.
Let me ask you a question. What do the bylaws of the homeowners association or any of those documents say about this?
The bylaws say that the board can come up with their own election policies and procedures with respect to their elections. The board did adopt policies and procedures with respect to their elections in Resolution 10, which is in the record. What that resolution says is the board uses a written ballot. It's called a ballot. The voting member can vote by proxy, by mail, or in person. When in person, they are directed to a voting room. There is someone in the voting room to oversee the voting room to make sure where they go to cast their vote, there's sufficient distance. When they cast it, they fill out their ballot, they fold it, and they put it into a ballot box and then exit the voting room. That is not a vote by a show of hands. That is not a voice vote. That creates an expectation of privacy, and our laws in this state support that. In Siegel, it was similar to this case in that if the ballot is disclosed, it will disclose the voter identity. Not all ballots do. In this particular case, like in Siegel, if the ballot is disclosed, it will show exactly who the voter voted for.
Can that be redacted so that that's not disclosed?
Well, that offer was made, Your Honor. However, the court ordered that the association produce the ballots in unredacted form. And that's why we're here and why
But we're still under a protective order there, correct?
But the protective order only protects against disclosure outside of litigation. There are several problems with that. The protective order provides no protection for how the candidate who she ordered would get every ballot and see who every voter voted for, how that candidate could use that information. For example, the candidate could then conduct a targeting campaign in the next election, which it was involved in. In addition, for the voter to know that their vote will be disclosed when they're voting for and against members who they live with in a small community, could suppress a voter turnout, which could also benefit a candidate, especially one like this one that gets 372 votes out of an approximate 1,000 vote election. So voter suppression could happen. It could create turmoil within the community once someone found out that someone knew who they voted for. And in addition to that, Your Honor, limiting it to litigation, the other side, I believe, takes the position that if an issue is presented to the court in litigation with respect to these votes, it then becomes public record and can then be communicated to the community members. So really, the protective order provides no protection at all with respect to the votes that are given to a candidate. This is not a situation where you have a third-party auditor viewing the votes, or you're asking the election oversight committee who is there pursuant to the bylaws and the election procedures to look at votes or recount votes. Here, the candidate is asking for every single vote, and I want to know who every single person voted for. That is an extreme intrusion on the privacy of a voter and could cause great damage as precedent in elections, because then any disgruntled candidate could come up with some reason why they contest the election and want to see who every voter votes for. It would turn elections on its face.
Well, let me ask you a question though, and I understand your arguments, understand the basis for your arguments, but there is no specific prohibition against this, is there?
I think pursuant to Mooney versus Phillips, our Supreme Court case, and pursuant to the bylaws and the interpretation of what a ballot is and the expectation of privacy when the ballot is used, I think that is the prohibition against it.
But going forward, if the homeowners association wanted to remedy this situation, it could simply by adopting a rule or policy or procedure, could it not?
To adopt a rule saying that ballots are not to be produced if requested?
Whatever it is that you're seeking here, or to adopt a procedure that would be that they could find agreeable.
Well, I guess that, with all due respect, I think that puts the cart before the horse. I think when
I understand that's not the question we're looking at, but here we're talking about a voluntary association where everybody has, I guess, a pecuniary interest involved because of ownership of property. It's not something that is strictly regulated by the state. There are rules out there, but there are also, as this case evidences, there is no specific prohibition for or against this.
I guess that to answer your Honor's question, and I'm about to run out of time if I may have additional time.
Go ahead. You can answer.
I guess to answer your Honor's question, the board could adopt policies that would get more specific and I guess more defensive with protecting the right of their homeowners. I guess the answer to that question is yes, they can adopt additional procedures. However, in adopting the procedure that a ballot is to be used in the manner in which it was used, and with the laws in this state on how the meaning of a ballot is to be interpreted, and the expectation of one's right to vote in private, when you couple all of that, I think it was reasonable to assume that the homeowners association thought they had taken the necessary steps to state that a voter was going to cast their vote in private and that it remain private. And the Siegel court cited other cases that acknowledged that the right to a secret vote in the context of the state, as you ask, is vital for a democracy to function. Like that logic, the right to a private vote when a homeowners association has done so with respect to its procedures is vital for it to function as well. And
you've answered my question.
Thank you.
Thank you. We will hear from the appellee.
Good morning, Your Honors. I'm
Morning.
Shannon Van Tol, and I, along with Adrian Anderson, represent the Appellee Rarity Bay partners in this case. And we're asking that you affirm the trial court's decision in all respects in this matter, because Chancellor Bryant got it right when she ruled that the association's election records, including ballots, are discoverable and must be produced in this election contest case. For this court to adopt the association's position would mean that ballots are never discoverable and that members of a nonprofit corporation never have the ability to challenge election results. More dangerously, their position means that the director of a nonprofit corporation whether they're validly elected or not, to maintain control over the corporation and all of its finances and insulate themselves from any liability or accountability whatsoever to the membership for invalidly conducted elections. And we submit that's not the law in Tennessee, and it can't be the law in Tennessee. This court needs to affirm the chancellor's decision for 3 reasons. First, the chancellor is absolutely right. Those ballots are corporate records and they're subject to discovery in this election contest suit. Second, the ballots are corporate records of the Nonprofit Corporation Act. And under the law of this state, members of a nonprofit corporation have the right to inspect the corporation's records. And the reason they have that right is so that they can protect their interests in cases like this one. And third, under the facts of this case, there are no privacy rights in those ballots. The Nonprofit Corporation Act does not create privacy rights in those ballots. It doesn't even require that ballots be used. The charter of the nonprofit corporation does not require vote by secret ballot and does not require that ballots be used. The bylaws of the nonprofit corporation do not require that vote be by ballot or secret ballot. What the bylaws say in section 7.7 is that the board may adopt procedures for either a secret ballot or may adopt procedures for a written ballot or may adopt procedures for computer votes. The bylaws don't specify how these elections are to be conducted. And the procedures that were employed by this association do not create privacy rights in the votes either. Because when you look at the facts of this case, as they're set out in the verified complaint in this matter, because this is a derivative action, according to the association in the election report they issued after the election, there were only 42 ballots cast in person at the annual meeting, and the balance of them were cast early, quote, given to Monica at the office. Those were the procedures. And we submit that given votes to Monica at the office do not create privacy rights in the ballot that would allow this association to keep its records from its membership. Now, when your honors are looking at this case and evaluating Chancellor Bryant's decision, I think it's important that you take a look at the decision she rendered. Because though the issue of whether ballots are required to be produced under the Nonprofit Act is an issue of first impression and very interesting, that wasn't the basis for the court's ruling. What Chancellor Bryant ruled was that these ballots are discoverable within the scope of this derivative action. And I'm going to take a minute to read to you her ruling. And this is on page 27 of the proceedings on January 20th, 2021. Here's what the court said. I looked at these motions yesterday and read them all. This is a lawsuit and this is discovery. This is not what you have to do to your members. This is not what you have to do in your normal course of business. It may or may not be, but I find that these records are discoverable, that they should be produced. They will be covered at this time by a protective order until we have supplemental argument, if necessary, on the separate issue of whether they are able to be disseminated. I agree that the board in most situations shouldn't be allowed to act in secret and not have documentation of what they've done. I haven't read every bit of this act for all those arguments for this case, but I think the members are entitled to transparency and the documents requested in the scope of the lawsuit are discoverable. That was the chancellor's ruling. And when the association asked the chancellor to reconsider her ruling, the chancellor made additional findings. In the order denying the reconsideration, she said, there's no way for the plaintiff to prosecute this case without appropriate discovery. There is nothing stated on the ballot or in the association's election procedures that states the association's elections are secret. There's no showing that it would be to anyone's detriment to reveal the ballots under the protective order. And we submit, your honors, that the record supports the trial court's ruling and that she ordered the production of these ballots subject to a protective order, restricting the disclosure of who voted for whom, except as needed in this litigation. And that was an appropriate exercise of the trial court's discretion in this case. The record supports the trial court's ruling. If you look at the verified complaint, you'll see detailed allegations showing that Rarity Bay Partners candidate for that election lost by only 1 vote. The election report the association has produced shows that they didn't count 3 votes. It also shows that the vote roster that they claimed to have used for that election contained multiple errors. It allowed defendant SPC 25 votes for property that had never been annexed into the subdivision. It allowed Bald Eagle, the other defendant in this case, 3 votes that it shouldn't have had. So the chancellor had all this in front of her in the context of a derivative action when she ordered these ballots for discoverable, and the record supports her decision in that regard. The record also supports production of these ballots because they are records of this nonprofit corporation. And under the law of Tennessee, corporations have to make their records available to shareholders or members upon proper request for a proper purpose. And the reason the law is that way is because members of a nonprofit corporation or homeowners association should have the ability to protect their rights. They should have just as much right to these corporate records as what these directors have who are withholding them, especially in the context of this derivative suit, where you have a plaintiff with more than 5% of the voting power who brought the suit. And there's a broad common law right of inspection that Tennessee courts have recognized, and we cite the cases in our brief. But in 1962, the Tennessee Supreme Court, and it was in the Lowell Wiper Company case, recognized the broad right shareholders have for the inspection of records. And the court explained in that case that the fact that a statute was enacted to specify that shareholders have the right to stockholder books did not mean that the statute replaced the common law right or restricted the common law right. Instead, these statutes that govern shareholder inspection rights are meant to make it easier for shareholders to exercise their rights. And that's why under the Nonprofit Corporation Act, the legislature, and under the For-Profit Corporation Act, I mean, it's identical. I mean, under Tennessee law, the inspection rights of shareholders of a for-profit corporation are the same as those of a nonprofit corporation. But both sets of statutes set forth an expedited procedure so that when an association or a corporation wrongfully denies shareholders or stakeholders of their right to inspect records, the trial courts of this state are required to consider that application for the inspection of records on an expedited basis. And the trial courts of this state are required to award attorney's fees and expenses. And the purpose is because the legislature wants to make it easy for shareholders and members of nonprofit corporations to exercise their inspection rights. And the broad legislative intent in favor of inspection rights is also reflected in the language of the statute itself. In TCA 4866-101E4, the corporation is required to keep the minutes of all meetings of members and records of all actions approved by members for the past 3 years. Now, this is different than the Siegels case. The Condo Association Act is different because the statute in that case said the condo association shall produce minutes of meetings. That's not what you have here. What you have here is a nonprofit act saying that nonprofit corporations are required to keep minutes and also records of all actions approved by members. And we submit that there's no more fundamental action of the members of a corporation than its vote for directors. And especially under the governing documents of this case, because one of the few actions that members are required to take under the governing documents of this case is that they're required to elect directors. And half of the directors are supposed to be elected at every annual meeting. They serve staggered terms. So the association's duty to keep records of all actions approved by the members must include the duty to keep records showing that the members voted in approval of the specific directors that the association claims was elected. And the ballots should be produced on that basis. The Nonprofit Corporation Act also requires the association to keep appropriate accounting records. And it doesn't set forth to define every accounting record that must be kept. And I encourage you to look at the statutes being analyzed in Siegel, because The Condo Association Act does define what accounting records that a condo association must produce to members, but the Nonprofit Act does not. And what it says is it says that the association must keep appropriate accounting records. It doesn't set forth to specify. And in the context of the facts of this case, you've got a board of directors who has exclusive authority over all of the corporation's finances. They get to make the assessments, they get to do the collections, they get to be on the accounts, they get to spend. They have exclusive control of all the association's finances. So at a minimum, we submit that appropriate accounting records include those accounting records that show that the people you have exercising exclusive control over the association's finances are authorized to exercise that control and have been duly elected. So the ballots should be produced under the Nonprofit Act because they are accounting records of this association, and the association should not be able to keep its records from its membership. Finally, there's been a lot of discussion this morning about privacy rights, and the association wants you to construe the Nonprofit Act against this backdrop of the Tennessee Constitution requiring votes to be secret in governmental elections. But I submit, Your Honors, that the proper starting point for determining whether these voters have privacy interests in their vote is the governing documents in the statutes that govern the corporation. You see, corporations are statutorily created entities. And to the extent that shareholders have rights or expectations with respect to their relationship to the corporation, those rights come from the statutes, the Nonprofit Corporation Act, and from the association's governing documents, its charter, its bylaws, and the procedures it implements. In this case, the Nonprofit Corporation Act does not require directors to be elected by ballot or secret ballot. The charter of the association has no requirement for director elections to be by ballot or secret ballot. The bylaws allow the association to put in procedures for a secret ballot or to not put in procedures. They allow the association to allow for computer voting or to not, but the association never implemented procedures requiring secrecy of the vote. Shareholders never had that expectation under the facts of this case, because a majority of these votes were cast before the election. And when you look at the ballot, it says at the bottom that they can be mailed, they can be faxed. And when you look at the election report the association submitted, a majority of them were given to Monica at the office. That doesn't create some super privacy right that should trump the discovery rules of this state that make those ballots discoverable in this election contest case. There's nothing in these governing documents that should excuse the association from its obligation to produce its records to members upon a proper request for a proper purpose. And if ever there was a proper request for a proper purpose, it exists in this case under the claims made in the derivative action that's been filed. But I see that I'm running out of time. I'm happy to entertain any questions Your Honors have.
I see none. Thank you.
Thank you.
We will hear from the appellant in rebuttal.
Yes, Your Honors. I do want to make a couple of things clear. Bylaw 7.7 allows the board to adopt its own election procedures, and that is what would govern the homeowners association. The board did adopt its election procedures in Resolution 10. The board did, in those procedures, adopt policies for a ballot. Our Supreme Court has interpreted what a ballot means with respect to elections, and it is secret. And the Resolution 10 also goes through the pains that are taken by the Homeowners Association to ensure that when casting the vote, it's secret. There have been other jurisdictions where the argument has been tried, well, the candidate voted by proxy, therefore there's no expectation of privacy, or the candidate mailed in their vote, and therefore there's no expectation of privacy. Those arguments have failed. In fact, the Tucson case that the appellee cites to the court for Arizona law, years later in 2007, that case was distinguished when it came to that state's Nonprofit Act and a homeowners association, and the ballots were not allowed to be produced. Now, in all candor, in that case, it's not to be cited under Arizona law unless certain requirements are in place. I can give your honors that site if you wish. In the California case that was relied upon by Siegel, and the Chantilly's case, where it was also a homeowners association and the California court did not allow production of ballots, there was an argument made, well, the votes were cast by proxy, therefore they weren't private. The court rejected that. There was an argument in our own state in the Smith versus Winfield Dunn case, which was cited by the Siegel court, involving persons who were blind going to the polls and whether someone assisting them in their vote would breach the privacy requirement. And the court held that it didn't. And there was a fear that, well, if someone's blind, whoever is casting their vote for them may mark the wrong person. And the court did not allow the fear to overtake the laws and the privacy interests and the means to go forward with our election procedures. So there was definitely a privacy interest that the homeowners should be allowed to rely upon. The appellee has stated facts, has stated allegations as though they were facts. I don't have time to get into each and every one, but you will notice that they allege that there were votes cast by parties in this case that would be beyond the margin of error. And yet they want to see every vote of every member and who that member cast their vote for. Why would that be? It is improper. It's an extreme invasion of privacy, and it would cause great harm to elections in this state if it were allowed to be disclosed. Thank you.
Thank you. Thank you, counsel. We appreciate your argument. We will endeavor to get an opinion resolving this matter to you at the earliest point possible. Mr. Hibner, anything we need to take up before we recess the court till the call of the next case?
No, Your Honor.
All right, you may recess court. Thank you again, counsel.
Thank you.
This honorable court is now in recess until 1:30 p.m.